Settling on a probability of survival that should count as viability is another matter. Is a fetus viable with a 10% chance of survival? 25%? 50%? Can such a judgment be made by a state? And can a state specify a gestational age limit that applies in all cases? Or must these difficult questions be left entirely to the individual attending physician on the particular facts of the case before him? The viability line, which Casey termed Roe's central rule, makes no sense, and it is telling that other countries almost uniformly eschew such lines. The court thus asserted raw judicial power to impose, as a matter of constitutional law, a uniform viability rule that allowed the states less freedom to regulate abortion than the majority of Western democracies enjoy. All in all, Roe's reasoning was exceedingly weak, and academic commentators, including those who agreed with the decision as a matter of policy, were unsparing in their criticism. John Hart Ely famously wrote that Roe was not constitutional law and gave almost no sense of an obligation to try to be. Archibald Cox, who served as Solicitor General under President Kennedy, commented that Roe reads like a set of hospital rules and regulations that neither historian, layman, nor lawyer will be persuaded are part of the Constitution. Lawrence Tribe wrote that even if there is a need to divide pregnancy into several segments with lines that clearly identify the limits of governmental power, interest balancing of the form the court pursues fails to justify any of the lines actually drawn. Mark Tushnet termed Roe a totally unreasoned judicial opinion. Despite Roe's weaknesses, its reach was steadily extended in the years that followed. The court struck down laws requiring that second trimester abortions be performed only in hospitals. Akron v. Akron Center for Reproductive Health Incorporated, 1983, that minors obtain parental consent. Planned Parenthood of Central MOV Danforth, 1976, that women give written consent after being informed of the status of the developing prenatal life and the risks of abortion, that women wait 24 hours for an abortion, that a physician determine viability in a particular manner. Colati, that a physician performing a post-viability abortion use the technique most likely to preserve the life of the fetus, and that fetal remains be treated in a humane and sanitary manner. Justice White complained that the court was engaging in unrestrained imposition of its own extra-constitutional value preferences. And the United States as amicus curiae asked the court to overrule Roe 5 times in the decade before Planned Parenthood v. Casey, and then asked the court to overrule it once more in Casey itself. When Casey revisited Roe almost 20 years later, very little of Roe's reasoning was defended or preserved. The court abandoned any reliance on a privacy right and instead grounded the abortion right entirely on the 14th Amendment's Due Process Clause. The court did not reaffirm Roe's erroneous account of abortion history. In fact, none of the justices in the majority said anything about the history of the abortion right. And as for precedent, the court relied on essentially the same body of cases that Roe had cited. Thus, with respect to the standard grounds for constitutional decision-making text, history, and precedent, Casey did not attempt to bolster Roe's reasoning. The court also made no real effort to remedy one of the greatest weaknesses in Roe's analysis, its much criticized discussion of viability. The court retained what it called Roe's central holding that a state may not regulate pre-viability abortions for the purpose of protecting fetal life, but it provided no principled defense of the viability line. Instead, it merely rephrased what Roe had said, stating that viability marked the point at which the independent existence of a second life can in reason and fairness be the object of state protection that now overrides the rights of the woman. Why reason and fairness demanded that the line be drawn at viability the court did not explain. And the justices who authored the controlling opinion conspicuously failed to say that they agreed with the viability rule. Instead, they candidly acknowledged the reservations some of us may have in reaffirming that holding of Roe. The controlling opinion criticized and rejected Roe's trimester scheme and substituted a new undue burden test, but the basis for this test was obscure. And as we will explain, the test is full of ambiguities and is difficult to apply. Casey, in short, either refused to reaffirm or rejected important aspects of Roe analysis, failed to remedy glaring deficiencies in Roe's reasoning, endorsed what it termed Rod's central holding while suggesting that a majority might not have thought it was correct, provided no new support for the abortion right other than Roe's status as precedent, and imposed a new and problematic test with no firm grounding in constitutional text, history, or precedent. As discussed below, Casey also deployed a novel version of the doctrine of stare decisis. This new doctrine did not account for the profound wrongness of the decision in Roe, and placed great weight on an intangible form of reliance with little if any basis in prior case law. Stare decisis does not command the preservation of such a decision. Workability. Our precedents counsel that another important consideration in deciding whether a precedent should be overruled is whether the rule it imposes is workable, that is, whether it can be understood and applied in a consistent and predictable manner. Casey's undue burden test has scored poorly on the workability scale. Problems begin with the very concept of an undue burden. As Justice Scalia noted in his Casey dissent, determining whether a burden is due or undue is inherently standardless. Whether a burden is deemed undue depends heavily on which factors the judge considers and how much weight he accords them. The Casey plurality tried to put meaning into the undue burden test by setting out 3 subsidiarity rules, but these rules created their own problems. The first rule is that a provision of law is invalid if its purpose or effect is to place a substantial obstacle in the path of a woman seeking an abortion before the fetus attains viability. But whether a particular obstacle qualifies as substantial is often open to reasonable debate. In the sense relevant here, substantial means of ample or considerable amount, quantity, or size. Random House Webster's Unabridged Dictionary 1897. Huge burdens are plainly substantial and trivial ones are not, but in between these extremes, there is a wide gray area. This ambiguity is a problem, and the second rule, which applies at all stages of a pregnancy, muddies things further. It states that measures designed to ensure that the woman's choice is informed are constitutional so long as they do not impose an undue burden on the right. To the extent that this rule applies to pre-viability abortions, it overlaps with the first rule and appears to impose a different standard. Consider a law that imposes an insubstantial obstacle but serves little purpose. As applied to a pre-viability abortion, would such a regulation be constitutional on the ground that it does not impose a substantial obstacle? Or would it be unconstitutional on the ground that it creates an undue burden, because the burden it imposes, though slight, outweighs its negligible benefits? Casey does not say, and this ambiguity would lead to confusion down the line. The third rule complicates the picture even more. Under that rule, unnecessary health regulations that have the purpose or effect of presenting a substantial obstacle to a woman seeking an abortion impose an undue burden on the right. This rule contains no fewer than 3 vague terms. It includes the 2 already discussed undue burden and substantial obstacle, even though they are inconsistent. And it adds a third ambiguous term when it refers to unnecessary health regulations. The term necessary has a range of meanings from essential to merely useful. See Black's Law Dictionary 928, 5th ed. 1979. American Heritage Dictionary of the English Language, 1975. Casey did not explain the sense in which the term is used in this rule. In addition to these problems, one more applies to all 3 rules. They all call on courts to examine a law's effect on women. But a regulation may have a very different impact on different women for a variety of reasons, including their places of residence, financial resources, family situations, work and personal obligations, knowledge about fetal development and abortion, psychological and emotional disposition and condition, and the firmness of their desire to obtain abortions. In order to determine whether a regulation presents a substantial obstacle to women, a court needs to know which set of women it should have in mind and how many of the women in this set must find that an obstacle is substantial. Casey provided no clear answer to these questions. It said that a regulation is unconstitutional if it imposes a substantial obstacle in a large fraction of cases in which it is relevant. But there is obviously no clear line between a fraction that is large and one that is not. Nor is it clear what the court meant by cases in which a regulation is relevant. These ambiguities have caused confusion and disagreement. Compare Whole Women's Health v. Hellerstedt, 579 U.S. 582. 2016, Slip OP, ed. 39, with ID, et. Alito, J. Dissenting, Slip OP. 24-25 and N11. 2. The difficulty of applying Casey's new rules surfaced in that very case. The controlling opinion found that Pennsylvania's 24-hour waiting period requirement and its informed consent provision did not impose undue burdens, but Justice Stevens, applying the same test, reached the opposite result. That did not bode well. And then Chief Justice Rehnquist aptly observed that, the undue burden standard presents nothing more workable than the trimester framework. The ambiguity of the undue burden test also produced disagreement in later cases. In Whole Women's Health v. Hellerstedt, the court adopted the cost-benefit interpretation of the test, stating that, the rule announced in Casey, requires that courts consider the burdens a law imposes on abortion access together with the benefits those laws confer. But 5 years later, a majority of the justices rejected that interpretation. 4 justices reaffirmed Whole Women's Health's instruction to weigh a law's benefits against the burdens it imposes on abortion access. But the Chief Justice, who cast the deciding vote, argued that nothing about Casey suggested that a weighing of costs and benefits of an abortion regulation was a job for the courts. Roberts, C.J., concurring. And the 4 justices in dissent rejected the lead opinion's interpretation of Casey. Alito, J. dissenting. Joined in relevant part by Thomas, Gorsuch, and Kavanaugh J.J. This court's experience applying Casey has confirmed Chief Justice Rehnquist's prescient diagnosis that the undue burden standard was not built to last. The experience of the courts of appeals provides further evidence that Casey's line between permissible and unconstitutional restrictions has proved to be impossible to draw with precision. Casey has generated a long list of circuit conflicts. Most recently, the courts of appeals have disagreed about whether the balancing test from Whole Women's Health correctly states the undue burden framework. They have disagreed on the legality of parental notification rules. They have disagreed about bans on certain dilation and extraction procedures. They have disagreed about when an increase in the time needed to reach a clinic constitutes an undue burden. And they have disagreed on whether a state may regulate abortions performed because of the fetus's race, sex, or disability. The courts of appeals have experienced particular difficulty in applying the large fraction of relevant cases test. They have criticized the assignment while reaching unpredictable results. And they have candidly outlined Casey's many other problems. Casey's undue burden test has proven to be unworkable. Plucked from nowhere, Rehnquist, C.J. It seems calculated to perpetuate give it a try litigation before judges assigned an unwieldy and inappropriate task. Lehnert v. Ferris Faculty Association. 1991, Scalia. J. Continued adherence to that standard would undermine, not advance, the even-handed, predictable, and consistent development of legal principles. Payne, 501 U.S., at 821. D. Effect on other areas of law. Roe and Casey have led to the distortion of many important but unrelated legal doctrines. And that effect provides further support for overruling those decisions. Members of this court have repeatedly lamented that no legal rule or doctrine is safe from ad hoc nullification by the court when an occasion for its application arises in a case involving state regulation of abortion. Thornburg, O'Connor, J. The court's abortion cases have diluted the strict standard for facial constitutional challenges. They have ignored the court's third-party standing doctrine. They have disregarded standard residential judicata principles. They have flouted the ordinary rules on the severability of unconstitutional provisions, as well as the rule that statutes should be read where possible to avoid unconstitutionality, and they have distorted First Amendment doctrines. When vindicating a doctrinal innovation requires courts to engineer exceptions to long-standing background rules, the doctrine has failed to deliver the principled and intelligible development of the law that stare decisis purports to secure. June Medical, Thomas, J. Reliance interests. We last consider whether overruling Roe and Casey will upend substantial reliance interests. Traditional reliance interests arise when advance planning of great precision is most obviously a necessity. Casey, plurality opinion, in Casey. The controlling opinion conceded that those traditional reliance interests were not implicated because getting an abortion is generally unplanned activity, and reproductive planning could take virtually immediate account of any sudden restoration of state authority to ban abortions. For these reasons, we agree with the Casey plurality that conventional, concrete reliance interests are not present here.